International Court of Justice is now in session. President Shahabuddeen and the Honorable Judges Meesen and Brand presiding.
Please be seated.
The case before the court is the matter of Nicchia versus Mercuria. The applicant and the respondent are each allocated 45 minutes to present their case.
The court meets today for the oral proceedings in the case between Nicchia and Mercuria. The proceedings were instituted by notification to the court on 11 September 1990 of a special agreement between the parties. That agreement provided for the submission to the court of a dispute between them concerning the international trade in electromobiles. The memorial and counter-memorial were duly filed within the time limits fixed, and there have been no further pleadings. The written proceedings thus closed. The case is now ready for argument. The court notes the presence of the agent, advocates, and counsel of each party. Pursuant to the procedure prescribed by Articles 31 and 58 of the Rules of Court, the court has decided that it will first be addressed by the representatives of the government of Nicchia, and then by the representatives of the government of Mercuria. I accordingly now give the floor to Ms. Rita Tripathi, the leading counsel for Nicchia.
Good morning, Your Excellencies, Mr. President. May it please the court, my name is Rita Tripathi, and this is my co-agent, Mr. John Gormley. We are counsel for the applicant, Nicchia. We have reserved 5 minutes for rebuttal. Would Your Excellencies wish to hear a brief recital of the facts?
Please do, but make effective use of the limited time that you have.
Certainly. In developing its EMO industry, the Nicchian government coordinates competition with the Industry Association. Mercuria has responded to Nicchian competition by enacting legislation which allows Nicchian sales in Mercuria to be restricted. This quota is triggered by practices in Nicchia by Nicchians. By compromise, Nicchia and Mercuria have agreed to submit all issues in this dispute to this honorable court. This morning, I will address the issue of jurisdiction. My co-agent will address the issue of the GATT and the UNRBPC. Specifically, I will make 3 submissions before the court today. First, the applicant submits that the Mercurian legislation seeks to regulate conduct within the state of Nicchia. Second, the applicant submits that Mercuria cannot rely on the effects doctrine to establish jurisdiction over the Nicchian economic activities because it is our submission that the effects doctrine is not a principle of customary international law. And third, the applicant submits that if this court recognizes some form of the effects doctrine still exists today, then it is our request that the court apply it pursuant to a balance of interests approach. To begin with my first submission, may I refer the court to page 1 of the applicant's memorial. It is a well-established principle in international law that a state has jurisdiction with respect to activities within its own territory. From this principle, it follows that Nicchia has jurisdiction with respect to economic activities within Nicchia. It also follows that Mercuria does not have jurisdiction with respect to the economic activities of Nicchia, that activities that occur within the state of Nicchia and in accord with Nicchian economic law. The applicant submits that the Mercurian legislation seeks to regulate control over Nicchian economic affairs. For example, the actions of Mercuria are in fact tantamount to an interference with the economic sovereignty of Nicchia. The competition law amendment enables the cartel office to limit for sale in Mercuria goods that originate from other states whose law is not in accord with Mercurian law. The result of this cartel order is to make Nicchian access to the Mercurian market subject to Mercurian laws, subject to a restructuring of their economic policy. The second submission is that Mercuria cannot rely on the effects doctrine to establish jurisdiction.
Sorry, Councillor, let me come back to your first submission. I'm reading in the facts that one of the elements of that order adopted by the cartel office is related to the allocation of markets outside Nicchia, or Nicchia, however you want to pronounce the name of your country. Would you submit that even with respect to this element of the order of the cartel office, there is some conduct to be regulated within Nicchia, even though the order itself states it to the contrary?
It is the applicant's submission that the export market allocation, in fact, is still activity that is controlled within Nicchia. And although there is no evidence of direct effects in, it is our view that there's no evidence of direct effects in Mercuria, because Comcar and Elect are only two companies that are within Mercuria. The effects of the coordination of Comcar and Elec are greater within Nicchia, where there is some kind of coordination, but we would submit that within Mercuria there is still competition between other manufacturers in addition to Comcar and Elec.
But where do you implement such alleged practices as allocating markets? Is it in those markets that are being allocated, or is it elsewhere?
It is our submission that the Nicchian government policies are implemented and concluded within Nicchia, and that there isn't enough evidence of direct effect in Mercuria of our market allocation to conclude that it would occur within the state of Mercuria.
Well, but within your first submission, are you relying on the effects doctrine, or are you not relying on a territorial principle when you pointed out earlier that your charge is that this order relates to conduct within Nicchia?
Certainly, Your Excellency, the distinction that you're drawing between the effects doctrine and the territorial principle is recognized by the applicant. We choose to rely on the broader effects doctrine, although it is our belief that we would also come within the territorial principle because the activities are, in our submission, concluded and implemented within Nicchia. If the court feels that some part of the activity is occurring within the state of Mercuria, then our argument will still hold because we will choose to embrace the wider effects doctrine in our argument today.
Very well.
Counselor, if you would, has any international body ever limited the territoriality principle in the manner which you are suggesting before the court today?
Certainly, Your Excellency, could you clarify the question?
You're asking us to rely on a theory of territoriality in effect, in rejecting an effects test, are you not? And I'm asking you, is there any authority for that limitation in the body of international law available to us?
Authority for the distinction between territoriality and effects?
Authority for the limitation you propose upon a territoriality principle.
Certainly. We will be relying on a distinction between criminal activity and economic activity. And later in our argument, I will cite cases to you that have limited territoriality to a balance of interests approach.
Why don't you move to that now so that we can...
Certainly.
I'd like to hear what you have in terms of the international authority for your position.
Okay. Would you wish to hear the submissions supporting the argument that the effects doctrine is not a principle of customary international law, or would you prefer that I move directly to the balance?
I guess simply answer the question, what is it in international law that limits the territoriality principle in the manner in which you are suggesting to the court?
Certainly. An examination of state practice would reveal that foreign governments are very quick to react to any attempted application of the effects doctrine. For example, numerous states have actually passed blocking statutes to resist the application of the effects doctrine. Further, if we look at the statistics of comparison, they also support the assertion that the effects doctrine has been met with greater opposition than with acceptance, and that is why it is not a principle of customary international law. For example, if we look at the statistics of blocking statutes, we see that for every 3 blocking statutes, there is but 1 cooperation agreement. For every 5 diplomatic protests, there is but one cooperation agreement. Further, it is our submission that the United States, the most frequent and vociferous user of the effects doctrine, would not apply or would rarely apply the effects doctrine to conduct occurring entirely outside the state of Nicchia, outside the state of the United States by non-Americans. And if the court accepts that the market allocation occurred within the state of Nicchia, then this in fact is a case where conduct is occurring entirely outside of Mercuria by non-Mercurians. Further, from our extensive research, we were unable to come up with even one instance of a state conceding jurisdiction because another had employed the effects doctrine.
Tell me, Counsel, my understanding is you have seen the briefs of the other side, and I just wonder what would be your comment on the position adopted on this problem you are discussing just now by the Court of Justice of the European Communities in the wood pulp case. Are you familiar with that somewhat cryptic statement by the court, and could you explain your reading of that judgment to us?
Certainly, Your Excellency. The wood pulp case, although the Advocate General argued for the effects doctrine, the court actually rejected it in that case. It is our submission that the principle laid down was objective territoriality. Therefore, if the court accepts that the market allocation was in the state of Nicchia, then the wood pulp can be distinguished, because in the case before the court, the activity, it is our submission, was not implemented or concluded within the state of Mercuria.
Counselor, we're dealing here with a case that involves economic conduct. You've told us, not criminal conduct, but economic conduct, and that makes a difference.
That's correct, Your
But
Excellency.
certainly the economic conduct, the sales of the EMOs is carried on in Mercuria, in part here, and that's the primary concern of Mercuria, is it not?
That's correct, Your
And you're telling
Excellency.
us then that Mercuria has no right to be concerned with the manner in which sales of EMOs is carried on in its own jurisdiction? You're telling us that international law prevents them from being concerned with that?
Certainly not, Your Excellency. International law prevents them from passing jurisdiction that seeks to regulate conduct within the state of Nicchia. International law would not preclude them from passing laws within Mercuria, for example, to stop the branch plant. But instead of stopping the branch plant, they have chosen to regulate activity within the state of Nicchia and chosen to violate the General Agreement on Tariffs and Trade, as my co-agent will demonstrate.
Well, then they're using a less restrictive method than preventing the branch plant, are they not? They're allowing the branch plant, allowing sales from the branch plant. That's actually less restrictive, and I can't see why Nicchia would now complain about a less restrictive method if you have just, as you told us, agreed that a more restrictive method would be allowed.
In fact, the restrictive method of preventing a branch plant does not necessarily mean that this will result in less sales from Nicchia. For example, by the way that the law is now, they are reducing the imports that can come from Nicchia to 14%. A 14% that would include the branch plant and Nicchia. Although we would have no argument if they were to pass a law preventing a branch plant, because that would not violate international law. But instead, they have chosen to go around this by seeking to control activity within the state of Nicchia.
Well, may I ask for your help on this aspect? You're standing your case on two legs. You're saying first that Mercuria has interfered with the exercise of your economic sovereignty, and you are seeking to develop and to establish an international norm to that effect. Secondly, you are saying that Mercuria is in violation of an applicable GATT provision. Now, suppose the cartel order had been slightly reworded. As it stands, it does two things. It imposes a quantitative restriction, and it is also injunctive of certain conduct carried on by Nicchia. You pronounce it Nicchia. But suppose it had been reworded this way. Instead of being injunctive of those activities, suppose it had read this way, that so long as Nicchia, in fact, engages in certain activities, a quantitative 14% restriction would apply to Nicchia in Mercuria. Would that order constitute an interference with your economic sovereignty, as distinguished from possibly constituting a violation of some applicable GATT provision?
It is our position that it would still, by restricting it to the 14% and putting a norm on restrictive practices, that it would be still interfering with our economic policies. And yes, that would still be an interference. If I may now move to my third submission, Your Excellencies, and that is that the applicant concedes that some states do still apply the effects doctrine with respect to competition law. However, even the respondent would concede that when the court does apply when states do apply the effects doctrine pursuant to competition law, that they do so only with a balance of interests approach. And it is our request today before this court that you also do this. Apply a balance of interests approach. There are several factors that the court may look to in applying this balance of interests approach. For example, Judge Choi in Timberlane would request that the court look to the extent to which Nicchia has an explicit purpose or intent to harm Mercuria.
Sorry to refer you again, Counsel, if I may, to the wood pulp case. What do you think was the position of the Court of Justice regarding that balancing of interests test that you are making reference to now?
Your Excellencies, I would interpret wood pulp as perhaps giving one leg of a balance of interest reasonable approach. For example, wood pulp could stand for the proposition that a reasonable approach to the effects doctrine would be if the effects were direct, foreseeable, and substantial. And on this reading, it is our contention that that the effects of Nicchia are not direct, and they must be direct. It would instead seem that they are, the effects in Mercuria are perhaps because of Mercurian preferences for Nicchian EMOs. Perhaps because Mercuria is unable to perform as an efficient EMO, but not a direct result. As to the substantial issue, it is our contention that 1.5% per year to approximately 10% is not substantial. The Mercurian government, in fact, instigated the 14%. It is hard for us, for Nicchia, to feel that the 10% can be substantial, would fit the substantial requirement, given that Mercuria would agree to a 14%.
You're talking about the balancing consideration, and your case on that point rests heavily on the averment that the development of the Nicchian economy is dependent on the EMO trade. But now, has any reduction in the volume of your trade resulted as a consequence of what Mercuria has done?
At this point, our branch plant is not built in Mercuria. Once the branch plant is built in Mercuria, this will result in a reduction because the cap is 14%. This 14% includes the exports from Nicchia and the branch plant. This will effectively reduce the 14%. On the final leg of the balance of interest, the German approach would say...
Have you got evidence on record to support that thesis?
Because the branch plant is not yet built, we do not yet have the evidence. But by
have you developed that in your written pleadings?
That the result, yes, we have.
Would be that the result of the operation of these measures would effectively be to stifle the completion and operation of the branch plant?
No, Mr. President, not that it would stifle the completion of the branch plant, but if the branch plant were built and were continued on and the 14% were left, that in effect that would lower our exports. Because the 14% limits for sale all Nicchian EMOs, including the branch plant and the 14% on exports. Therefore, this will lower our export amount because it will include both the exports and the EMO.
I don't wish to unsettle the scheme of your argument.
I see I'm out of time. May I briefly conclude?
Yes.
Okay.
Yes.
The German, just to conclude with the...
Would you conclude in say, 2 minutes?
Certainly.
Yes.
The German approach would advocate that the court should balance the interests of Nicchia in its administrative support of its EMO industry against Mercuria's interest in forcing Nicchia to abandon its policy. the applicant submits that a useful test for this court today would be to ask what would happen to the respective states if we were to take away its EMO industry. For Nicchia, a newly industrialized country, it is argued that perhaps this could mean an entire collapse of its economy to take away its EMO industry. In fact, what may result is that Nicchia may revert to the status of a developing country. For Mercuria, as an industrialized state, it is our submission that what would happen if we took away the EMO industry would be a slightly reduced market share. That's all. In conclusion, Your Excellencies, it is the submission of the applicant before the court today that first, the effects doctrine is not a principle of customary international law and cannot be applied to competition law. And second, if the court accepts that some form of the effects doctrine exists, as some states do, then it is requested by the applicant that the court apply a balance of interests approach, and that on this approach, Nicchia's interests must outweigh those of Mercuria. And that concludes my argument, Your Excellencies. If you have any further questions, I would address them at this point. Thank you very much.
Thank you very much. Now, the court invites Mr. Gormley.
Good morning, Mr. President. Good morning, Your Excellencies. As co-agent for the applicant nation of Nicchia, I wish to make 3 additional pleadings before this honorable court this morning. First, Mercuria has violated the General Agreement on Tariffs and Trade. Secondly, Nicchia's economic policies are in full compliance with international law and the GATT. And thirdly, the United Nations Restrictive Business Practices Code is not customary international law and does not bind Nicchia in this matter. With respect first to GATT. Mercuria has breached the GATT in several respects. It has first violated the clause which forbids quantitative restrictions. It has not extended most favored nation to Nicchia, and it has no grounds for an escape clause action. With the indulgence of the court, I would like to now address these GATT issues. Article 11 of GATT is the elimination of quantitative restrictions clause. It prohibits governmental decrees or orders which place quotas, which restrict the import of goods to a certain proportion of the market. Mercuria's cartel office order, dated March 1990, specifically sets a limit of 14% on the sale of Nicchian-made EMOs in the market of Mercuria. Indeed, this cartel office order does not specify imports, as Mr. President had asked earlier about this relationship, but it is the contention of the applicant state, Your Lordships, that by implication and through a finding of inference on behalf of the court, that the court take notice that to regulate 14% of total Nicchian EMO sales into Mercuria by factoring in a branch plant will by implication include present import levels. This is a governmental decree which sets a limit. It affects the sale of EMOs from Nicchia to Mercuria, and we would contend it is a quota in violation of Article 11. Although quotas such as this are a breach of the GATT, they can be relied on for an exceptional purpose.
Let me ask you a question. Suppose we followed your point regarding exports from Nicchia to Mercuria, that there may be an involvement of Article 11. Would the same hold true regarding the EMOs produced in Mercuria itself? Wouldn't the ceiling of 14% set by Mercuria, to the extent it applies to EMOs produced by those transplants of Nicchian companies in Mercuria, be in conformity with Article 11 of the GATT?
On the facts, Your Excellency, we do not know if a substitution effect has taken place or will take place. But it would be the contention of Nicchia that indeed the respondent at page 2 of respondent's memorial concedes that this is a quota in violation of Article 11, and then attempts to justify it under Article 19, which we plan to attack. But on the case law, Your Excellency, it is difficult for us to make a finding that imports will be affected. Beyond the processed fruits and vegetables panel, I believe it was 1979, involving the EEC, which found that certain measures which have an effect of limiting the sales in the country can be held to be an import quota, and we would hold by
Well,
this.
in my supposition, I did not deny that this may indeed constitute an import quota with regard to the EMOs produced in Nicchia and afterwards exported to Mercuria. But as you know from the facts, both the amendment to the Mercurian competition law and the specific order adopted by the Federal Cartel Office relate not only to the exports from Nicchia to Mercuria, but also to the EMOs produced by the transplants, if I may use this colloquial term, by those plants set up by Nicchian companies within Mercuria. So wouldn't, to that extent, it would be trying to find the law perhaps between your application and the one of respondent. What would you say? In what way is the GATT involved regarding limiting sales of transplants?
In that respect, Your Excellency, we would contend that under Article 3, if the transplants are treated differently, we would contend that there may be an Article 3 violation.
Could you elaborate on that?
Under Article 3, Your Excellency, that is the requirement in the GATT that nations be accorded national treatment. And we would contend that by discriminating on the basis of national origin, namely Nicchian-held companies, that may be in fact violative.
Have you authority for that reading of Article 3 in earlier GATT practice?
With respect to earlier GATT practice, there have been a number of cases that blur the distinction perhaps between foreign direct investment, and indeed it is a country's own internal economic control over foreign direct investment. For example, in the Canada-US FIRA case. However, if there starts to be certain requirements attached to that foreign direct investment, namely in the Canada-US FIRA, it was the question of sourcing of materials, there may in fact be a violation of Article 3. And we would believe that by singling out Nicchian-owned firms, and again, as my co-agent has explained, to try to assert control over practices within Nicchia, that may in fact be held to be not according the same treatment.
But Counsel, you're talking about investment here and not trade in goods. In the U.S.-Canada case, in the Investment Review Act, the foreign sourcing resulted in trade in goods. Is there anything in the facts before this court that would lead us to believe that there are trade in goods involved here in the aspect that would implicate Article 3 in the manner you have?
There is nothing on the facts, sir, that respect the actual sourcing of goods or materials. It is more a question of political control, and we would contend admitting Article 11 as a quota violation using a quota for a political purpose, which is to object to certain other economic policies.
Let me ask you then, even if we accept your argument under Article 11, why is there not an Article 20D defense here?
Article 20D involves compliance with domestic laws which themselves are not a violation of GATT. And we would contend that based on several cases recently, that Mercuria in this instance has not shown, although they may be applying certain measures, they may have certain reasons for undertaking those measures in compliance with the Spring Assembly's case, there has become a stricter test for the rationale of domestic laws, as enunciated in the Screwdriver's case, that there must be some enforcement of the obligation, not merely the general objective. And we would contend that the general objective in this situation is to regulate Nicchian conduct. And as far as a trade dispute, we do not believe that that would relieve them from the GATT obligations.
But the test under 20D is, isn't it, that there are necessary measures to enforce laws that are otherwise consistent with the GATT?
Yes.
And it seems to me the laws that are attempted, the enforcement attempted here is of the competition laws of Mercuria. Is that not correct?
Indeed, enforcing it extraterritorially, yes.
Okay, so then are you saying that under 20D, are you saying either that the Mercurian competition laws are inconsistent with the GATT, or are you saying that the measures are not necessary to enforce those laws? Which aspect of 20D are you focusing on here?
We are saying that the measures in this case, which are attempting to enforce competition law through trade policy, are not consistent. In this respect, what is happening is that they are using a quota and attempting to justify it as an emergency escape clause action, much like the Nicaraguan sugar imports case, where there is not a grounding that this is indeed emergent or of an exigent nature to show such a sufficient emergency.
Is there a manner in which they can enforce their competition law, given their concern in this case, that would be more consistent with the GATT than this measure? I mean, if there's not, then we may have to find that it's necessary, might we not?
Well, on a strictly logical basis, we would believe that in terms of the amendment, which sets to extraterritorially apply their competition law, and then using the cartel office order to single out such nations, could be narrowed, and perhaps on the basis, in this case, of taking certain GATT-consistent action. For example, in this case, waiting until they do have the grounds for an emergency action once negotiation has proceeded and proved fruitless. We do not believe they are yet at an emergency level. We would like to attack in our issue, or perhaps choice of better words, address Article 19, which in this particular case has been pleaded by the respondent as a justification for its Article 11 action. And in this particular case, we believe Article 19 is not sustainable for several reasons. First of all, with respect to the general definition of Article 19, to restrict trade if imports increase unforeseeably and to such an extent as to cause or threaten serious harm to domestic or serious injury to domestic producers. Nicchian exports to Mercuria have not caused or not threatened serious injury, and they are not unforeseen. The Hatter's fur case, for example, which the respondent has relied upon, involved a 28% decline in market over the period of 18 months. In this case, we have a gradual, incremental increase of 1.5% a year for the past 6 to 7 years. In terms of the labor force dislocation in Hatter's fur, it was 16% in just under 18 months. In this case, while we do not see in the facts of the case a specific number, we would contend that given the magnitude of the change of consumer preference in Hatter's fur, such a magnitude of change has not occurred in this case. The time factor indicates that it was not unforeseeable. We're dealing with a period here of 6 to 7 years. There has not been the radical type of change that was established in Hatter's fur. Mercuria can also further not claim serious injury because the present level of Nicchian imports at approximately 10% is below what the manufacturers in Mercuria had agreed to. They had agreed to 14% in their voluntary agreement with the Nicchian manufacturers. Mercuria has also not met the procedural requirements. Professor Jackson, as well finding some authority in the U.S. Williams Commission report in 1971, refers to Article 19 as being of a temporary nature. Quote, rigorously justified by modernization and diversification by the firms that have been adversely affected. So it is, in essence, an attempt to, if I may use the vernacular, to buy time while industries affected modernize and diversify.
Councillor, if you permit me to, we have seen this discussion in your brief. What I would like to know, where I was not able to get particular enlightenment from reading your written pleadings, is what actually is your reaction to the counterclaim of Mercuria. Do you have a reaction at all? And if so, what would be your grounds?
Our grounds for the counterclaim particularly involve perhaps a unique perception of the facts before this court when one counterposes or juxtaposes often conflicting political ideologies. There is indisputable evidence that Nicchia has a government that is quite interventionist in the economy. It has been the approach of the Nicchian state, at least since 1972, to work cooperatively with manufacturers and be perhaps more interventionist in the economy than many of the industrialized countries would find favor with in their democracies. This has paid both economic and social dividends. 350,000 new jobs in a previously underdeveloped area, and the development of an EMO industry.
But couldn't that conduct qualify for a type of restriction to imports that in fact you were charging to have been committed by Mercuria? This government-induced practices of somehow securing a safe haven for Nicchian industry?
We would reply, Your Excellency, with two points to the answer, and excuse me if I appear to go on at some length on this issue. One is the policy aspect, and the other is the Article 3.4 defense under GATT. The policy aspect is that this is fully justifiable as domestic consumer law. Again, in many other industrialized countries, the notion, for example, with the standard distributorship agreement, where a distributor could use capitalized goodwill, namely the customer lists, and would go from manufacturer to manufacturer saying, my customer base expands, the service expands, we'll now carry your vehicle. And while indeed this would result in some rapid change of product and continued moving technologically, in a developing or a newly industrialized country such as Nicchia, the government has taken the position, and it's fully defensible as a social policy position, that in order to protect the Nicchian people who purchase those EMOs, again, and EMOs are a unique vehicle in that they must be brought to a service center at least once a month. So the people are protected because they have bought in goodwill an EMO knowing that they would have service at that facility. If it were to move out from under them, many, particularly of the people unable to afford to keep technologically advancing their cars, would find that their service has fallen. Indeed, in the old days when the world relied on automotive power and gasoline, this was not quite as important. Some people would go even twice a year to get their car serviced. But it is... I'm sorry.
I don't particularly want to stop you from explaining this point. However, to me it sounds a political point, whereas we are confronted here with a legal evaluation, and therefore I wonder, without in any way commenting on the wisdom of that, as you portray it, consumer-oriented policy, which all the same is going along with some overpricing of the product. What is actually the ground where you would believe you could rely upon to defend yourself against the counterclaim on GATT grounds?
I apologize, Your Excellency, for not getting to the law sooner. We would look under GATT Article 3.4, which requires treatment no less favorable to imports than laws which apply to domestic goods. The Spring Assembly's case upheld that on the general applicability principle of not distinguishing imports from domestic. This law, if one looks on the face of it, irrespective of the origin of an EMO, even to a new EMO manufacturer in Nicchia, the same standard distributorship principles apply. An EMO that arrives from any other country must comply with this domestic consumer legislation. So it would be our contention, for example, that there is no bar under this to Mercuria entering the EMO market. Mercuria has faced high land values and a deeply rooted Nicchian policy, but it is not stopped from or barred from for example, opening up 1 or 2 service centers in the larger domestic cities.
But Councillor, isn't the practical impact of these distributorship agreements, even though we may not find them troublesome under Article 3 of the GATT, in effect a quota under that's violative of Article 11? I mean, it effectively sets a zero quota when the necessary arrangements have, and it seems to me the compromise tells us, made it nearly impossible for foreign EMO manufacturers to enter the Nicchian market.
We would reply to that respectfully, Your Excellency, on 2 points. First of all, on the facts, nothing bars a manufacturer from opening up, again, at a very localized level, if they are unable to provide statewide distribution facilities, for example, in the largest cities, distributorship and service centers. With respect to the claim, it would be our contention further under Article 20D, as we discussed with the bench earlier, that this is a domestic policy designed to apply certain measures, which in this case are designed to be local consumer law.
But then, under 20D, it must be necessary to the enforcement of a law that's otherwise consistent with the GATT. Now, what is it then? It's a law that's otherwise consistent with the GATT.
We would believe that in this respect, it is justifiable domestically for competition and consumer policies, which are not GATT violative in this case. The respondent would argue that they have been prevented from entering the market. We would say that, as my co-agent argued earlier, this is a question of land values and local consumer preferences, and perhaps a diminution of the competitive ability of the larger EMO countries.
If it's an issue of land values and local consumer preferences, why do you need the restrictive clauses in distributorship agreements? I mean, the fact is that if they can get their batteries recharged at a maintenance facility, does it really make a difference that the maintenance facility is restricted for 5 years from recharging batteries for any other type of EMO?
With respect,
how does that protect the consumer?
With respect, Your Excellency, it protects the consumer that as certain consumer products begin to evolve and move, again, remembering this is monthly servicing, there may be some who are marginalized. Indeed, marginalized to the extent that their batteries are no longer available because the forces of the market have driven it to another type of battery servicing, and we believe that is defensible. Again, perhaps...
Is there anything in the facts to show that that has occurred at all here in Nicchia?
Factually...
Do the facts support that position at all?
We would believe, by implication, the facts can be interpreted by the nature of the Nicchian state, which is much more interventionist at a governmental level than perhaps the Mercurian state in the larger industrialized countries. But Nicchia has used state involvement to bring the country to a position of developed economy, and we would believe this would be quite consistent with Nicchian political policy.
But if you're at that position, then the GATT should apply, should it not?
Indeed, the GATT should apply, Your Excellency, and we believe that it is affording national treatment, and there's nothing on the facts that prevents Mercuria from entering the Nicchian market. I see I'm out of time. I wanted to briefly...
Could I ask you one small question on which perhaps you might be able to help me? I see that your attack is against both the order made by the cartel body as well as against the amendment made to the competition law. Now, am I right in thinking that the amendment made to the competition law doesn't actually authorize the cartel board to make a cease and desist order? It only authorizes it to impose quantitative restrictions in certain circumstances. Is that right?
I believe that is correct, Mr. President. It enables the cartel officer.
I'm not trying to sideline the discussion into a question of virus. But I pass on to this question. The amendment to the Act is only enabling, is it? It doesn't actually impose any quantitative restrictions. Is that right?
That's correct, Mr. President.
Now, since you're nevertheless challenging the Act, which neither imposes any quantitative restrictions, nor authorizes the cartel board to make a cease and desist order. Am I right in thinking that your case must be this, that the amendment to the Act falls within the category of acts which by their very existence constitute an infringement of an international norm? It doesn't do anything, it's only enabling. You nevertheless challenge it. Why?
We challenge it, Mr. President, given the fact that it is the enabling statutory or legislative vehicle to extend extraterritorially the law of Mercuria upon the law of other nations. And when my co-agent argued earlier, that was the position that she had addressed. The cartel office order then specifically names, in violation of the GATT, certain parties and certain measures upon which Mercuria undertakes.
But what do you complain of? Do you complain of the mere existence of an act of parliament? Or do you complain of the actual consequences which you suffer as a result of something done under the authority of that act?
In the most direct sense, Mr. President, we are affected by the consequences and come to this court today to complain of them. I had some comments on the United Nations Restrictive Business Practices Code, but I see my time has long elapsed. If the bench has any questions on the UNRPBC, we would be pleased to address them. If not, we will address them at a later point.
You have time for a rebuttal.
Thank you very much. We will hear the other side at this stage, I think.
Thank you, Your Excellencies.
Then I invite Mr. Dan Leary. Thank you. Please proceed.
May it please the court, my name is Daniel Leary, agent for the respondent, the government of Mercuria. My co-agent is Cynthia Counts. Today, I will address for this tribunal the proposition that the state of Mercuria has violated no principles of customary or conventional international law, either in the passage of the amendment to the law against restraints on competition, or in regards to the cartel office order enforcing that law. My co-agent, Ms. Counts, will address the principle that the Nicchian government, by lending administrative support to the restricted business practices of its electromobile industry, has violated customary international law as embodied in the Restricted Business Practices Code. With the court's indulgence, I will address the issues in the reverse order that they were presented by the applicants. I will start with the violations of the GATT alleged by the applicants by Mercuria, the violations by Mercuria, and will then move to the jurisdiction exercised by the cartel office in the enforcement of that law. Mercuria has not violated the most favored nation principle as embodied in Article 1 of the General Agreement on Tariffs and Trade. The underlying law in this case is the Mercurian law against restraints on competition. The amendment applies that law to foreign bodies, all foreign bodies, not simply Nicchian corporations or other nations' corporations, but to all nations' corporations. Nicchia is given the status of a most favored nation, as the corporations of Nicchia, as well as the corporations of, say, the United Kingdom or the Federal Republic of Germany, or any other third-party nation, are treated the same under Mercurian law. There is thus no violation of the most favored nation requirement. There is also no violation of Article 13's requirement against the discriminatory imposition of quantitative restrictions. Since the law is neutral, the restriction in this case is a sanction for the violation of Mercurian law. Nicchia is the only nation that is reflected in the compromis as having violated that law. As a result, there is no discrimination in applying that particular sanction only to Nicchia, so long as they are the only nation which is actually violating the law. Were more nations to violate the law and not be subject to restraint, then that would be a violation of the requirement. But there is no indication in the compromis that that is the case before this court today.
Excuse me, Counselor, how are we to separate this law from its implementation by the cartel office? It seems to me that given the law as it is stated, it's a little difficult to imagine a case that wouldn't be focused on one particular source and therefore implicate the MFN issues under Article 3.
The MFN issues, Your Honor, are contained under Article 1.
MFN, the non-discrimination under Article 3 as well as MFN under Article 3, or Article 1.
Your Honor, there's a two-part answer to your question. In the first instance, the law itself, the law being applied, is the law against restraints on competition, and that is applied equally to all foreign nationals, the Nicchians as well as any other foreign nationals who might wish to enter the Mercurian market. Thus, they are not subject to a handicap under Mercurian law that another nation does not have to operate under. With regards to the national treatment provision of the GATT, contained in Article 3, that refers only to goods which have already entered the territory of another nation, and their sale and distribution within that market. The article specifically refers to the word imported goods as compared to the Article 1 and Article 11 use of the word importation of goods, suggesting that they deal with the transport across the border, whereas Article 3 deals with the marketing and sale when they are within the nation in question, in this case Mercuria. There are no restrictions on Nicchian goods once they enter the Mercurian market. They may be sold and traded as may any Mercurian goods. They are under no additional restriction once they cross the border. It is the submission of the Mercurian government that this constitutes a border restraint, and as a result, the proper method for analysis is the use of Article 11, if this court would allow, and Article 19's defense to any possible conflict with Article 11.
If you bring in Article 9, then are you admitting a facial violation of Article 11?
Your Honor, we are not admitting a facial violation of Article 11, as there has, as of yet, been no actual restriction of the Nicchian imports into Mercuria. There has only been the notification that once the level of importation reaches 14% of the Mercurian market, that ceiling will be established at that point.
That's the definition of a quota, is it not?
Yes, Your Honor, that would be at the 14% limit. And if this court were to decide that it was, as it stands now, already a quota, then we would submit that we are in fact entitled to the protection afforded under Article 19, as we have met all of that article's requirements, both procedural and substantive. Under the substantive requirements of Article 19, there are three requirements which the state claiming the protection must meet.
Tell me, would you not rely on Article 20?
Your Honor, we could also rely on Article 20.
Could you explain that?
Certainly, Your Honor. Under Article 20D, a nation may take any means which are necessary to enforce laws that are otherwise consistent with the GATT, provided that those means of enforcement are necessary. This is a necessary means for the enforcement of Mercurian competition law. The only other possible way which we could bring the Nicchian corporations into conformity with the competition law would be to impose some sort of tariff or other restraint which would also violate the GATT. As a result, it is necessary to impose a GATT-conflicting remedy under our law in order to enforce the competition law against Nicchian corporations and other foreign corporations, as well as against Mercurian corporations.
But Mercurian competition law, does it not contain other remedies which are quite significant and of a deterrent nature? And don't you think that, or would you be able to refer to any other competition law which includes such a trade sanction as a remedy? Would you perhaps comment on this point of necessity by reference, let us say, to other well-known competition laws such as those of the United States, of the European communities, which do not at present rely on this type of remedy?
Certainly, Your Honor. The United States does have a similar statute to that enacted through the amendment to the Mercurian competition law in Section 301 of the Trade Act of that nation, which does allow this sort of imposition on a finding by the Federal Trade Commission that a nation is engaging in unfair business practices. The amendment and that provision are substantially similar in their wording, and they do apply in similar circumstances, that being that the underlying justification for the law can be found in the fact that these sorts of practices give rise to a situation allowing the imposition of restrictions under Article 19 of the General Agreement on Tariffs and Trade. The European community has not adopted such a restriction. However, they have considered it, and it has been put before the European Parliament in the past, thus implying that it is something under international law which is being considered as a possible means of states enacting their GATT obligations. As was pointed out by your distinguished brother on the bench, this is simply a means of enabling the cartel office to make this decision. It is clearly within the realm of Mercurian sovereignty to decide when a violation of Article 19 has occurred. All the amendment actually does is place that particular segment of Mercurian sovereignty in the cartel office as opposed to in the legislature. The amendment still amounts to a finding that there has been a violation of principles which would allow an imposition of a restriction under Article 19. The finding is simply made by the cartel office as opposed to being made by the legislature.
Well, are we not trying to find out what is necessary in the context of Article 20D, and if we have a record of decades of rather effective enforcement of antitrust laws, and if we also find in the record of this case that Mercurian law provides for imposition of fines of up to 10% of annual sales, isn't that an effective remedy? In what way do you think could such trade remedy add anything to the effectivity of Mercurian competition law?
Your Honor, it is a necessary remedy for the imposition, the enforcement of Mercurian law. As the Nicchian applicants' agents have laid out before this tribunal today, they intend to continue these practices within their own nation. They're resisting our counterclaim, claiming that these practices are a violation of international law, and saying they are necessary for their development. We cannot stop the corporations from engaging in these practices outside of Mercuria. We must stop the contaminated products, the products which have benefited from these restrictive practices at our border. The Mercurian law only attempts to enforce Mercurian trade principles within Mercuria. We do not attempt to reach outside of Mercuria and enforce our law in Nicchia. The difference here is a difference between a prescriptive type of jurisdiction, that being that to pass a law saying that these principles are not to be used in Mercuria, and enforcement jurisdiction. Without the quantitative restriction or the 10% fine or a tariff, it would not be possible for us to get enforcement of our law, because the actions actually take place outside the territory of Mercuria. It is the effects which are felt within Mercuria, and we seek to eliminate the effects both through the passage of the amendment and the use of Article 19 and our exercise of jurisdiction over these activities.
What do you say in answer to the point made by Nicchia that you are in default of filing a written notice required under the GATT regulations?
Your Honor, we would submit in this case that we are not in violation of that particular requirement, as we have not actually affected Nicchian imports as of yet. The ceiling is set at 14%. Their current import level is 10.5%. With their average rate of increase, it is not anticipated that within the life of this order, which is 1 year, that they will reach that level of importation. Thus, there will be no actual restriction of Nicchian importation. What is currently occurring is an Article 22 procedure. Article 22 of the GATT refers to consultation among contracting parties over difficulties arising under the agreement. The Nicchian and Mercurian governments were working this problem out among themselves. Both parties reached the conclusion that we could not settle this dispute without outside arbitration. It was determined at that point by both nations agreeing that rather than referring this to a GATT dispute resolution panel, which would be the normal requirement under Article 19 to provide notice, that we would notify the International Court of Justice as there were issues in addition to the GATT issues involved. The filing of the compromise should serve as the written notification. The Nicchians were consulted with all along under Article 22, and the underlying purpose of Article 19, Section 2 on notice is that no party be taken by surprise and that all means to resolve the dispute amicably be exhausted before resolution to these procedures under Article 19, the imposition of unilateral measures.
Thank you. I'd like to follow up on that, if I may. That seems an interesting reading of Article 19, because Article 19, Paragraph 2 talks about before any contracting party shall take action pursuant to Paragraph 1. And you're saying the taking of action under that language really means when the customs officers at the border say, no, you can't bring this EMO. And it doesn't mean, but it seems to me that Article 19 doesn't really talk about that. It talks about the setting of quotas. In effect, if you're talking about using it as a defense to Article 11, and if you set the quota, isn't that the act by the government? It's not the ministerial act at the border. It's really the discretionary act of setting the quota, is it not? And that has been done by the cartel office.
Your Honor, the Mercurian government would concede that that is an interpretation which is possible under the article, we would, of course, submit the other interpretation. However, under your interpretation, the proper remedy to be granted to Nicchia is not the withdrawal of the Mercurian law and the vacation of the cartel office order. If there has been a violation of a procedural requirement of Article 19, then the proper remedy is to compensate Nicchia for that specific injury caused by the violation of the procedural requirement.
But Article 9 is a defensive article, and you are asserting it here as defense, right? There's no, I mean, they're not saying they've been harmed by violation of Article 19. They're saying they've been harmed by violation of Article 11. And then Article 19 deals with your defense to that allegation, does it not? So, I mean, they're not, we'd really get a circular, long process if we took your interpretation, would we not?
I understand your concern, Your Honor. Perhaps if I were to divide the analysis of Article 19 in a different way. There are substantive requirements of Article 19 and procedural requirements of Article 19. If we have violated the procedural requirements of the article, if this court did find that to be the case, that would not eliminate our qualification under the substantive procedures. If we were to vacate the order and remove the law at that point, we could then simply file the written notice with the contracting parties, repass the law, and reinstitute the same order to comply with Article 19. The proper remedy under the GATT is to allow the contracting party invoking the protection if it has caused damage by abusing the principles. And this is somewhat stated in Article 19, Section 3, dealing with the withdrawal of return concessions by a contracting party unfairly harmed by an unfair invocation of Article 19. The proper remedy...
Why would you have to repass the law as well as to make the order all afresh? Is the quota fixed by the law or by the order?
No, Your Honor. It is simply an enabling piece of legislation. I was referring to a situation where the court
So why do you say you will need to repass the law then?
Only if the court were to find that the law and the order were in violation of international law. If only one is, then we would not have to go back quite that far. But the Mercurian government would submit that we have met all the requirements of Article 19. As far as the substantive requirements go...
I put that question to you in the context of the discussion on the procedure for fixing a quota. My colleague on my left made the point which you sought to answer. I don't know how convinced you are by your own answer. The point he made was that the notice requirement pertained to the fixation of the quota and not to the ministerial act at the customs frontier.
That is also a reasonable interpretation, Your Honor, that the amendment is completely outside the scope of the Nicchian's complaint. It should not be considered, as it is, only an enabling piece of legislation. With regards to the substantive requirements of Article 19, this was an unforeseen rise in imports. The language of the article is quite clear. It states, increased in such quantities and under such conditions as to cause a serious injury.
But even if we accept the substantive requirements have been met, if we find the procedural requirement has been met, then where does that leave you? Has not been met, then where does that leave you?
Your Honor, that leaves us with having to compensate the Nicchians for any damage they may have suffered due to the invalid procedural action taken by Mercuria. However, they have not suffered any harm because of this, as we have not restricted the importation of their product into our nation in any way. In addition, they have agreed to this 14% limitation on the importation of their product into our nation. They have not suffered in any way from the passage of the law or the imposition of the amendment, and as a result, they cannot complain of violations under it. With regards to the serious injury requirement, if I may move on to that, Your Honors, we have suffered a serious injury because the amendment and the article, nothing lays out exactly what constitutes a serious injury. It should not be subject to a numerical analysis. It should be looked at on a case-to-case basis based on what has happened. The purpose of the GATT is to allow things such as the rise of the global standard of living and full employment throughout the world. Those are two of the goals stated in the preamble on the first page of the treaty. We have not been able to satisfy the reallocation of our labor force due to the Nicchian incursion. We have suffered a serious injury as we have people who are out of work as a result of their increase in our market share. And that is the injury which we seek to redress. With regards to the jurisdictional issue before this court today, Mercuria has not abused its jurisdictional powers in the enaction of the law or the cartel office order. International law is a prescriptive rather than a permissive force. That is to say, as stated by the court's predecessor, the Permanent Court of International Justice, in the case of the SS Lotus, that which is not permitted by prescribed by international law is allowed under international law. This is particularly the case when, as is the case before this court today, Mercuria has only attempted to exercise jurisdiction within the confines of its own territorial borders. We have reached actions which have occurred beyond our jurisdiction, but all of those actions have produced effects within Mercuria, and is the effects on which we base the sanctions imposed on the Nicchian corporations. Now, there is no positive principle in international law that the effects doctrine is not an allowable basis of jurisdiction.
But the concept of sovereignty limits.
I think the question that are raised by the bench are very much the same. You are referring us to our statement in Lotus of some 65, nearly 65 years ago. And would you say your argument rests on that proposition of Lotus, that whatever is not prohibited is permitted under international law? Isn't there perhaps intervening case law where we have modified our position, and would you have no better argument to defend yourself against the Nicchian case than a reference to such a somewhat dated general principle, which even at the time has not found much applause in doctrine?
Yes, Your Honor, we do have an alternative basis. The principle, it is true, has been refined throughout the years, and as your brother on the bench began to refer to, the concepts of sovereignty do come in here and intercede to prevent the excessive exercise of jurisdiction. However, in this case, we have two interests of sovereignty involved. That of Nicchia in developing its industry and promoting that industry to become a successful world competitor, and that of Mercuria to protect a viable industry from an untimely demise due to unfair foreign competition. Mercuria, as well as Nicchia, has a sovereignty interest in this case. Mercuria has taken a reasonable and non-restrictive alternative, in this case, in only enforcing jurisdiction within the confines of its own territory. Our order does not extend beyond the borders of our nation. If the Nicchian corporations cannot comply with the requirements of our competition law, they do not have to compete in Mercuria. It is not necessary for them to change their law, but if they wish to compete in Mercuria with Mercurian corporations, we wish only to ensure that all corporations in Mercuria, whether they be Mercurian or Nicchian or of other national origin, compete on a fair and equal basis.
Consul, you have heard this statement made by counsel for Nicchia regarding the wood pulp judgment. What are your comments? Do you give that judgment the same reading?
No, Your Honor, we do not give that judgment the same reading. We would contend that the test under the wood pulp case is in effect broader than the test under the effects doctrine, in that it does not require a balancing of interests to be taken into account. That test only has two requirements. First, that an agreement be concluded between two or more parties. That agreement may be concluded anywhere in the world. And secondly, that it actually be implemented within the relevant jurisdiction. In that case, the European community, in this case, Mercuria.
Well, the main point of wood pulp is certainly on territoriality versus effects. And what is your reaction to that positive statement of the Court of Justice of the EC?
Our reaction to that positive statement, Your Honor, is that while it is true that in that case the European community did indeed base its jurisdiction upon the principle of objective territorial jurisdiction, they did not reject the effects doctrine. They simply found that it was possible to exercise territorial jurisdiction as they found the corporations in question actually present in the European community. With regards to the market allocation agreement entered into by the Nicchian corporations, those companies are actually, that agreement is actually implemented within Mercuria. I see my time is up. Might I have a few seconds to conclude?
Well, I would like, and I think this is in accordance with the rule, to follow up a little bit on this point, and I think you will be given a chance for a concluding statement. My question is regarding the effects doctrine. Suppose we were to follow your reading of the wood pulp decision. Is the effects doctrine unlimited, or are there any restrictions that have to be observed under the effects doctrine as well?
Your Honor, there are restrictions imposed by many countries upon the exercise of jurisdiction under the effects doctrine.
Which ones would you accept?
We would accept the balancing of interest test in this case, Your Honor.
And what about foreseeability and directness of effects? Would you accept those criteria as well?
Yes, Your Honor, we would, as we can satisfy them in this case.
Yes, and precisely regarding satisfying this, what would you say regarding this part of your of the order adopted by your cartel office, where the fixing of domestic prices of EMOs in Nicchia was considered a basis for certain remedies that we had discussed before. Is this fixing of prices in any way covered by the test of direct and foreseeable effects?
Yes, Your Honor, it is. When you fix prices in a market, certainly. When you fix prices in a market, Your Honor, what you do is you eliminate the competitive aspect of the pricing market, thus allowing corporations to reap higher profits as they do not have to compete with each other based on the price criterion. If they set prices amicably, there's no danger of fire sales and other sorts of low pricing methods to increase marketability. As a result, corporations are able to protect their profit margin. They use these profits, and this is stated in the compromis, they reinvest them in the export efforts, presumably of all 5 corporations, but certainly of Comcar and Elec, in going into Mercuria. It is a direct effect of these profits being taken from the price-fixing arrangement and reinvested into export efforts into Mercuria that the Mercurian economy will be affected as the competitive conditions in Mercuria are altered by this advantage. This is a substantial effect, as is also required under the traditional formulation of the effects test in Alcoa versus United States, in that it's substantial in that we have lost 10.5% of our market in a period of only 7 years, at least partially as a result of this practice, allowing these large funds to be accumulated to be reinvested into the Mercurian market. It is an intended effect as the profits are taken and a conscious decision is made by the Nicchian shareholders to reinvest these profits into exportation into Mercuria, thus satisfying all 3 elements as what has been characterized by some publicists under the new formulation of the effects doctrine requiring balancing as the nexus requirement under the effects doctrine, that being the direct, substantial, and intended effect upon the market economy, which is claiming the exercise of jurisdiction under the effects doctrine.
Which would, as a result, mean that any price fixing occurring in any local market anywhere in the world, since it allows to make profits, would be under the jurisdiction of any other state in the world, since on that market those profits could be used for particular export efforts. Is this indeed your proposition?
No, it is not, Your Honor. Our proposition is that in this case, the Nicchians have built an economic fortress which no one else has been able to penetrate. And they have used that position in order to attack outside of Nicchia and to capture other markets. In the particular case at hand that you describe, Your Honor, it would not be the same, say, for instance, if the profits were used to recapitalize in a developing country in order to expand the industrial base within that nation. That would be a different utilization of the profits from price fixing. There are limitations on the authority of developing states to interfere with such arrangements in states which are actually developing, unlike the newly industrialized state of Nicchia, which has a fully developed EMO industry, and also under the General Agreement on Tariffs and Trade, which allows some leeway for nations which are still developing. Those factors are not present in this case, and this is why we have the jurisdiction, that is the respondent Mercuria, under the competition law to reach the activities within Nicchia, but only to enforce against their effects and not actually to reach into their country and try and change their laws.
Could I just put one point to you on the aspect on which my colleague was testing your reading of the wood pulp case. I see that at page 12 in your county memorial, you say that the test that case established is even broader than the Timberlane test because it does not consider the interests of other affected nations. That is your position?
Yes, it is, Your Honor.
But I see that in the judgment, the court referred to that area of law and to the non-interference test. And then the next paragraph reads thus: there is no need to inquire into the existence in international law of such a rule. If the court took that position, is it right for you to say that what the court in fact did was to take a broader?
Yes, Your Honor, it is, because the
You
base...
said it wasn't ruling on it.
That's true, Your Honor, but that is because the basis of their jurisdiction was the territorial aspect. The fact that the subsidiaries of the wood pulp companies were actually present within the European community. As an example, if the Nicchian corporations go forward with their plans to build a branch plant within Mercuria, then we would have territorial jurisdiction over that aspect of the Nicchian corporations. In this particular case, we have territorial jurisdiction because the agreement to allocate markets cannot be implemented until it is completed. That is one definition of the word implement. It must be completed. It is not completed until the markets which are allocated, the agreement only allocates the markets. The actual market allocation occurs when the products are sent outside of Nicchia. When they reach Mercuria is when the market allocation actually occurs.
Thank you very much.
Thank you.
I invite your colleague, Ms. Kunz. You have the floor.
May it please the court, my name is Cynthia Counts, co-agent for the government of Mercuria. Today we ask this court to affirm the Mercurian counterclaim and declare Nicchia obliged to discontinue any further administrative support of restrictive business practices. Mercuria asks this court to declare that the Restrictive Business Practices Code, as passed by the United Nations General Assembly, actually embodies customary international law, and to find further that Nicchia has violated both the letter and the spirit of this law. In order to prove that a practice has risen to the level of customary international law, there are two necessary elements. The first, of generality of practice. That element is shown by a two-part test where you look to see if there are enough states from the various regions and ideologies of the world, and then second, that there has been acquiescence to that practice. The second necessary element for showing customary international law is that of opinio juris, the subjective element that nations feel bound to follow the law. In this case, there was sufficient generality of practice prior to 1980 to support the Restrictive Business Practices Code's legislation. Prior to 1980, almost all of the developed economies had antitrust legislation similar to that of the Restrictive Business Practices Code. Indeed, this code was modeled after the ECC Treaty of Rome, Articles 85 and 86, as well as the Federal Republic of Germany's legislation. Further, it is similar to the Sherman Antitrust Act of the United States, though it is probably more lenient than those provisions, only demonstrating that this is the very minimum to which the developed states agreed. But it wasn't only the developed states that had such antitrust legislation.
Councillor, if I may, I would like to ask you to tell us on what rule do you propose the court to rely upon in dealing with your counterclaim? What rule contained in that restrictive business practices code do you want us to consider and apply?
Well, the Nicchian government has violated several aspects of the Restrictive Business Practices Code.
Yeah, which one?
Well, they have violated the illustrative list of restrictive business practices in Section 3, D, 3 little a, and C as to price fixing and market allocation, which speaks to the corporations not engaging in such agreements as these, as well as Section 4, which talks about tying arrangements similar to the ones that the Nicchian government has engaged in, where there is the exclusivity arrangement of only the EMO manufacturers having the same distributorships as well as the non-competition restraints. This is the most egregious violation because it does limit access to the Nicchian market.
Well, Counsel, I have before me section D3, and when I looked into it, it is addressed in the first place not to states but to enterprises, and in the second place it has the language should refrain, and this term should, it is used throughout the restrictive business practices code. So I wonder in what way do you want to explain to us that we are confronted here with binding law as seen by those states and that have adopted the restrictive business practices code by way of resolution of the General Assembly of the United Nations?
Your Honor, those are two questions, and I'd like to break those down. The first, as to how the states have violated the Restrictive Business Practices Code. It is true that that section speaks to enterprises, but Section E of the code speaks directly to the states and asks them, in the similar language that you were talking of should, to enact and enforce legislation similar to that of the Restrictive Business Practices Code. The Nicchian government has not only failed to enact and enforce such legislation, but they have further flagrantly violated the code by administratively supporting such enterprises and engaging in the violations in Section D. But as to the binding nature of the code, resolutions can provide important evidence of the opinio juris, that of the feeling of obligations among the states. And there are instances when resolutions have had the force of customary international law quite apart from the non-binding language of the resolutions. For example, in the case of the United States versus Nicaragua, the Friendly Relations Act was cited as being customary international law in spite of the non-binding language. Another important example is that of the Space Declaration Act. In that instance, the United States and USSR had both been extensively engaged in space technology, but other nations had not had an opportunity because of technological deficiencies to spoke on their opinions as to the appropriate rules and laws. But this resolution has been noted by scholars as having the force of international law, even in spite of the non-binding force and language of that resolution. And the importance of this resolution for showing the opinio juris is that other nations, before not engaging in the practice, were able to give their feelings of the appropriate state of the law. In our case today, many nations prior to 1980 had not had the technological or geographical prerequisites to engage in international trade, but they did have an opportunity to express their will at the unanimous passing of this resolution in 1980, and they stated that they were in favor of the provisions of this code.
Excuse me. It seems to me in your memorial you rely on the argument that the customary rule was in effect established prior to the adoption of the General Assembly resolution, the code here. And you do that through references to various country practices, all of which are developed countries, are they not? And I think it's fair to infer here that Nicchia at that time was at best a developing country, and it was at that point without the code, would Nicchia have been bound by such a rule then?
Your Honor, prior to the code, if they were a developing nation, no, they would not have been bound even with the code,
Okay,
because there is Section C, 3 little I.
Okay, so then as to Nicchia here, your argument really does require us to accept that the code implements an international law rule through a General Assembly resolution.
At least, Your Honor, that it embodies the principles that began as early as the Havana Convention on Treaties, and then with the 1969 GATT Treaty, finally resolving in 1980 with the resolution with regard to restrictive business practices, because Nicchia was involved with the formation of this customary international law. In this case, the restrictive business
let me follow up on that. You mentioned GATT, but in GATT there was preceded by the negotiations on the International Trade Organization Charter, which would have included rules on restrictive business practices, and in fact those were not adopted. Doesn't that counter your position rather than support it?
No, Your Honor, because in this case, it was in 1980 that the nations from the various regions of the world were able to come together on the narrow and technical set of rules as general consensus. And all nations had an opportunity to express their will on the Code's provisions.
You're saying that a simple General Assembly resolution, or maybe simple is the wrong term, but a single General Assembly resolution indicates consensus. Why then wasn't it a convention rather than simply a General Assembly resolution?
Your Honor, this resolution is extremely important because it was passed by unanimous consensus expressing the will of all the countries, but also because of the formation of the Code. The Code was formulated by all the nations together. An intergovernmental group of experts got together and came up with the detailed provisions of the Code. And Nicchia would have been involved in this process because all the United Nations members had an expert agreeing with the formulation. If Nicchia did not intend to be bound by its solemn commitment in 1980, all they had to do was raise their hand in protest. They failed to do so. In failing to protest in this evolutionary process of customary international law.
Excuse me, Counselor, but the Code itself says in its preamble that the parties, even though they adopt this by consensus, and the question is, what is it they adopted by consensus? And it says, hereby agrees on the following set of principles and rules for the control of restrictive business practices, which take the form of recommendations. Now, that's not a binding statement, is it?
That is correct, Your Honor, but all United Nations General Assembly resolutions take the form of recommendations. The argument before the court today is that this Code embodies the principles agreed upon by the nations. Although the references earlier were to developed nations with antitrust legislation, Mercuria is not limited to only developed nations with this antitrust legislation. Instead, many developing countries had antitrust legislation even prior to 1980, similar to that of the Restrictive Business Practices Code. For example, Brazil and Argentina, India, Pakistan, the Philippines, several nations from various regions and ideologies, even Yugoslavia, a communist country, had antitrust legislation prior to the Code's adoption. This shows a sufficient generality of practice, but the Code gives evidence of the opinion juris.
Tell me, would your counterclaim stand or fall with our recognizing the validity, the legal validity of the Code, or would you have any other basis for your counterclaim to propose to us?
Yes, Your Honor. Not only do we believe that the Mercurian government suggests that this is customary international law, but the Nicchian government has also violated Article 11 of GATT. There is a distinction between Article 3 and Article 11, as my co-agent discussed, between importation and imports. Article 11 deals with policies that would set up quantitative restrictions to their markets. The Nicchian government, it is true, has not set up any direct quota, but the effect has probably been worse because there has been absolutely no access to their market. As is stated on page 2 and 3 of the compromise, numerous nations have tried to gain access to their market, but they have been unable to do so.
Yeah, but let me take this on a more general level. On the one hand, you rely on the Code and propose to us that what happened here was restrictive practices that harmed Mercurian business interests. And on the other hand, you now suggest to us to consider, if I do not get any enlightenment from you, I would have to assume to consider the very same type of action to constitute governmental action which qualifies for an infringement under the GATT. Could you explain this ambivalence of your argument?
Your Honor, the tying arrangements are actually for obligatory use under Nicchian law. So they are required by the government. And the policies, the effect of these tying arrangements is to completely prohibit access to their market. The United Nations Committee on Trade and Development has stated that these tying arrangements do have the effect of prohibiting access to the market, especially when combined with non-competitorship combinations.
But wouldn't that rule out any restrictive business practices on the private side? When you say it's governmental action, this tying arrangement, is it both at the same time? Is it restrictive, private restrictive business practice and governmental action at the same time? Or would you leave it to us to take the one or the other argument? What is your comment?
Certainly, Your Honor, we would be happy for you to take one or the other if it is a decision for the Mercurian government. But in this case, there is a basis for looking at the Restrictive Business Practices Code as a source of international law that speaks both to the states and to the enterprises. And when looked at in this light, it is clear that the Nicchian government has violated the code by administratively supporting such actions. The enterprises has violated the code by actually engaging in agreements as a dominant position of market power that is actually harmful to international trade and that prohibits access to their markets. It is the overall conspiracy of these agreements that are harming international trade and defeat the very definition of restrictive business practices in the code. Now, the Nicchian applicant does contend that they should be given special concessions because they have become dependent on this industry. Under Section C, 3i of the Restrictive Business Practices Code, there is preferential treatment to developing nations. However, the Nicchian applicant has stated before this court today that they are a newly industrialized country, as is stated in the compromise. The Restrictive Business Practices Code language is specifically limited to developing countries. Further, they do not deserve the sympathy of a developing country. They are not a fledgling industry, but instead, they have 100% of the...
Could you, refer me to language in the Restrictive Business Practices Code, which is exclusively in favor of developing countries?
Your Honor, under Section C, 3i, it talks about developing countries receiving preferential treatment when they are dependent on a trade.
I, and particularly that of developing countries is my text, which would not exclude to also favor the trade of other countries, such as newly industrialized countries or well industrialized and developed countries such as the one you are representing.
Your Honor, I'm sorry that if I misconstrued the code, but that still would not be detrimental to the Mercurian government because they are not going to deserve the sympathetic treatment of a developing nation. They are in a position of dominant market power that falls within the strict ambit of the code. They are in a position where they do not need protection, but rather where they can harm other people.
Well, should we rest our decision on sympathy, or should we rest it on law? What is your suggestion?
Your Honor, under the law of the Restrictive Business Practices Code, the Nicchian government does not fall within the exceptions. Instead of having a fledgling industry, which their entire country is dependent upon, they have an affluent market, an increasingly affluent market of over 80 million people. The Nicchian EMO industry has created 350,000 jobs. Clearly, there must be other industries in the country because what would the people be doing? They are not dependent on only the EMO industry for their competition and for their affluence. Instead, they are in a position where they have got complete control of their home market, and they have been able to gain almost 11% of the Mercurian market. This is a position where, through their markets, acting in concert together, the EMO industry has been able to create a safe haven at home while being able to create a one-way street into other markets. This is not acceptable under the Restrictive Business Practices Code because this is harmful to both developed and developing states.
Question, please. Nicchia, in its memorial, advanced with some strength the position that it was economically dependent on this particular industry. You are challenging that today, but you're challenging it, it seems to me, on the basis of facts which do not appear, do they? Did you in your memorial explore this area of fact as to whether or not Nicchia was economically dependent on this particular industry?
That is correct, Your Honor. In our memorial, we did not address the developing country status because we read the compromise to say a newly industrialized country and assumed that meant it was a country that was able to compete effectively in the world market. However, the Nicchian memorial does rely on this status, but they depend on the Norwegian fishery case, and that is distinguishable for both teams because as the bench has stated, there is nothing in the compromise that says one way or another whether they are completely dependent on the industry. Instead, the references to an increasingly affluent market to the only employing 350,000 suggest it might not. In the case of the Norwegian fishery, the members of that nation were dependent on fish in order to gain their livelihood. If you took away their ability to fish, they would not have that source of revenue. However, if the Restrictive Business Practices Code is enforced and the Nicchian government is not allowed to engage in such practices, they will not lose their effectiveness in the competitive EMO industry. They are clearly in a position now where they can compete. And instead, we will have a fair, level playing field where all nations will have the benefit of free international trade, which in 1980 they stated was best for both developed and developing states. Thank you.
Thank you.
Mr. President, Your Excellencies. By way of brief rebuttal, the applicant nation of Nicchia wishes to deal with 2 points. First of all, on the issue of GATT and the attempt by Mercuria to find defense for its quota under Article 19, we would submit there is no justificatory measure. Substantively, there's been no sudden surge of imports and no serious injury. More important procedurally, under Article 19.2, where it states, quote, before a state, quote, shall take action, unquote, there must be written notice to all contracting parties. This clearly did not occur. Publicists and case law also hold that a quota applied in such a way, as admitted by the respondent in its memorial that it is a quota, must be applied with the MFN principles of Article 13 of the GATT. We would look to publicists such as Professor Jackson. We would look to cases such as Norway and Hong Kong, where specifically QRs invoked under an escape clause of Article 19 must be subject to Article 13, not applied discriminatorily. Nicaragua sugar import quotas, though not emergency, the political import restrictions were a clear violation of MFN. We would look thirdly to Hong Kong and the EC in 1982. In Article 11 action on quartz watches, we quote, some question exists about the lack of consistency with Article 13. Neither MFN nor procedural requirements, among others, were met in an Article 19 action. Secondly, the Restrictive Business Practices Code. Professor Brownlee writes that UN resolutions are prima facie not binding on member states. They must express consistent world opinion. As the bench has dealt with the question of opinio juris, we would submit that there is no uniformity of state practice. Professor Davidow says, and I quote, almost all countries with antitrust laws nevertheless tolerate cartels in agriculture, professional sports, professions, and shipping, among others.
But not in manufacturing.
He states those specific ones, Your Excellency, but it would be our contention that there is simply no uniformity. Among even the form of this UN resolution, only 35 countries, according to Professor Ronald, even in their own domestic jurisdiction, have antitrust law. 35 countries of the world.
But more than that, we're involved in the consensus adoption of the Restrictive Business Practices Code. Is that not correct?
Indeed, and that's not...
And that's really the issue here, is whether or not this code, I believe the respondents admitted that even Nicchia probably wasn't involved in the development of the customary international law they presumed prior to the code. The question is, does that code, as a General Assembly resolution adopted by consensus, provide us with an international law rule?
Ab initio, it does not. It does not unless there is sufficient state practice in opinio juris. It is our contention that the very creators of the United Nations itself, in the UN Charter, Articles 10 and 13, say the mandate of the UN General Assembly is to discuss, initiate studies, and make recommendations. The very language of this code uses words like should repeatedly. It uses the word ought to. Various publicists agree that this particular code, I would cite Professors Davidow, Rosenthal, Brewer, Rahl, Bruswick, say that it is not in and of itself binding. Yes, countries participated in the creation of this code. I quote Professor Bruswick, who was a staff member of UNCTAD at the time. It was fast realized during negotiations of the UNRPBC that the international community was not ripe for the adoption of a mandatory agreement for the control of restrictive business practices. If the court, however, does hold that the UNRPBC should have binding authority, Nicchia's practice is under the definition, where at section B, small I, large 1, refer to a dominant market position in a relevant market. Nicchia does not hold a dominant market position in the Mercurian market. We would also submit that if the code is upheld, the reference, although to newly industrialized country from the point of view of Nicchia, in our memorial at page 25, we cite Professor Rubin, who states that newly industrialized is a stage of developing country. We concede freely that the group of 77 and the UNCTAD interpretation of developing countries has now grown to 125 countries, among them South Korea and Argentina. It would be our respectful submission to this honorable court today that the UNRPBC does not have binding authority, but if it does, we would reiterate by saying the business practices envisaged are not those of Nicchia, and if developing countries are to be given some support, we would concede that being newly industrialized does not foreclose that particular requirement. We would ask this honorable court, in the consideration of this argument today, grant relief for the state of Nicchia, which has so severely felt the effects of the extraterritorial application of a law and the GATT violative behavior of the country Mercuria responsible for it.
I just wonder, how do you react to the charge made that you yourself violated the GATT? What is your reaction there to? We don't have your response on that matter.
Earlier, Your Excellency, I had attempted to address some of the claims about a GATT violation, particularly under Article 3, the national treatment provisions. I would address the questions of market allocation, for example. Many industrialized countries, I think among others of the country of Canada, that has specific provisions where government assists exporters in attending trade fairs, doing market studies and market research. This has been upheld, I don't have the article in front of me, but I believe it's Article 9.3, which deals with the specific effects of this kind of market allocation.
Market allocation, I don't think it's the main point in that context. The main point I understand is that the system as it is run by Nicchia of having a government-guided industry is effectively preventing imports into Nicchia, and this is in fact what triggered the reaction on the part of Mercuria, and what is your comment there?
On a strictly evidential basis, Your Excellency, a number of factors have been identified that have perhaps foreclosed Mercuria from entering the Nicchian market. Among them are high land values and a deeply rooted buy Nicchian attitude. We have asserted from the beginning of this particular dispute that if Nicchian-made EMOs are gaining popularity inside Mercuria, perhaps it is a question of production and competitive product being offered. And no different from the nation of Nicchia, which has a deeply rooted national buying policy. We would defend the standard distributorship agreement under Article 3 as affording no less favorable treatment to imports than to domestic products, and even EMOs, irrespective of origin of any nation or even internally, all must comply with the distributorship agreement, which we believe in an economy perhaps unique from the market economies of the industrialized world, by its very necessity requires some degree of governmental involvement, perhaps objectionable to them.
Yes.
Thank you. That concludes the rebuttal of Nicchia.
Much obliged, Your Excellency.
Ms. Counts, you have the floor.
Thank you. Your Honor, Article 19 only requires the Mercurian government to show that they have suffered a serious injury. It is not necessary to have the sudden and rapid. Instead, in this case, there is clear evidence that we have lost almost 11% of our market and have suffered substantial unemployment that we have not been able to reallocate within our own industry. Furthermore, the Restrictive Business Practices Code is customary international law, and that alone should oblige the Nicchian government to discontinue its use of restrictive business practices. The Nicchian applicant does contend that there are cartels which should give exemption to the generality of practice. But if this resolution showed adequate consensus in 1980, then customary international law was established, and any subsequent violations were simply that, violations of the law. But furthermore, the actions spoke of are not necessarily, the exemptions by other countries are not necessarily the same, because the Webb-Pomeranian Act of the United States and the cartel orders by Japanese countries are much more narrow than the actions of the Nicchian government today. They are...
Sorry if I interrupt you. You mentioned Article 19 of the GATT, so I understand that you are also in charge of the GATT-related issues. I just wanted to come back to my earlier discussion with your co-counsel on Article 20D of the GATT. Is Mercuria now about to drop any reliance on necessity of its legislation, or would you be prepared to explain to us why indeed you think it is necessary to enforce a legislation which is enforceable under its very terms by way of fines up to 10% of annual sales? And in that respect, one point has, at least not to my own knowledge, been sufficiently answered. Is Mercuria, if indeed it maintains a position that the trade sanction is a necessary element to its competition law, if it also proposes that a 10% annual sales fine is unenforceable against companies that have in the meantime acquired a market share of some 12 or more percent in the Nicchian market? Aren't there assets within Mercuria which would allow, easily allow enforcement of such a high fine, and thereby completely deal with the enforceability of the competition law, so that no need would exist to take recourse to trade sanction.
Your Honor, we still contend that this is necessary to our laws, because although there is the 10% fine, there is still the contention by the Nicchian government that they would continue in their restrictive business practices that have been proven empirically to create a one-way street, which gives them an unfair advantage in our market that will still continue to damage us in a way that needs the emergency protections of Article 19. However, we are prepared to accept two decisions from this court today that would be beneficial to all of the nations. One would be simply to allow our order to stand and to give us the ability to protect through our emergency provisions under Article 19. But the second is to declare that the restrictive business practices counterclaim is international law. And that would simply require Nicchia obliged to discontinue its practices, which would then give us a fair level playing field. As of now, they have suffered no injury under our laws, and we could return to the status quo and to the solemn commitment of 1980 of a fair playing field. Thank you.
That concludes the ceremony. Well then, the position is that the issues presented have turned out to be of some complexity and difficulty. And the court would like to acknowledge the assistance it has got from both sides. With the benefit of that assistance, the court will now retire for its deliberations. Thank you.
All rise. The honorable court is now adjourned.
Takes another moment.